My internet is a bit slow. It's not going this morning.
Well, I'm feeling a little slow myself this morning.
Just like my internet. So that was funny, Mr. Gill. Okay, everybody. Good morning. My name is Judge Bonnie Janquet, Judge of the 171st Judicial District Court. It is 10 a.m. Because of this pandemic, the Texas Supreme Court has allowed us to participate and hold hearings via Zoom and YouTube Live. Mr. Fuel, Mr. Bowen, if either of you have any objection proceeding with these sorts of proceedings and their limitations, please let me know verbally right now.
No objection here, Judge.
Thank you, Mr. Bowen.
No objection, Your Honor.
Thank you. Thank you both very much. I want you both to know Ms. Anita Garza, my court reporter, is participating in this hearing as you would anticipate, and Ms. Rebecca Gonzalez, my court coordinator, as well as Rick Salazar, my bailiff. There's an options bar down at the bottom. If you want to chat or you want to go into a breakout room to talk, let me know. I will be more than happy to give you permission. At this point, I want everybody to know that we are on YouTube Live because of the Texas Open Courts provision. Okay, with that being said, we are going to begin our first hearing. It is a motion to compel. Whose motion is it, gentlemen?
My motion, Judge.
Okay. Very good. So you may go ahead and proceed, Mr. Bowen, please.
Judge, the upshot of our motion is to require the deposition of Odette Thomas. She is the managing partner of Ortiz Farms Partnership. I learned that of her position as managing partner when I received a copy of the Ortiz Farms Partnership. I guess a week ago, 10 days ago, something like that, and her deposition is what I would characterize as crucial for the proper presentation of my client's case. She being Odette Thomas would have the most I submit knowledge and familiarity with the vote that apparently took place, or the method by which the distribution were awarded and passed out among the family members. So it's really just crucial that I have that deposition. She has knowledge of how the apparently a vote was taken to award distributions among the family members, and of course the business about the distributions is the crux of this case. Who was involved in it, and how the decisions were made. We submit that my client was in effect cheated out of the rightful share of the distributions that were to go to her under the terms set forth in the settlement agreement that these parties entered into back in December 17, 2005. So Odette Thomas is a key crucial witness that certainly is a party in this lawsuit ought to have to testify to. So that's basically what we say, Judge.
Okay, thank you. Mr. Fuel, your response, sir?
Well, Your Honor, I have to clear up a couple of things if you don't mind. Robert Fuel, for the record, I'm sorry. and I'm representing Mr. Robert Ortiz. And as Mr. Bowen indicated, I'm also representing Odette Thomas. Odette, Mr. Bowen says he just learned that she's the managing partner, but Mr. Bowen was involved in the 2005 settlement, and they made Odette Thomas sign the settlement agreement because she was the managing partner and the person authorized to sign for the partnership, which is in fact the reason this court ordered me to provide the partnership agreement to Mr. Bowen sometime back, a few weeks back. So it's incorrect to say, it's just simply wrong to say that Mr. Bowen didn't know that fact. Mr. Bowen has been receiving all along since the 2005 settlement, the partnership returns. And in discovery, in this case, he received most of the partnership returns more than a year ago. And so he would have known from the partnership returns what distributions were made, and he would have also been able to observe that the distributions were made equally among the partners, as you would expect in a partnership where all the partners own their shares in the partnership equally. So this idea of somehow that perhaps somebody is jimmying the distributions so that his client is deprived of some share that she thinks she's entitled to doesn't bear out from the documents themselves and is patently absurd, frankly. I got a notice of deposition that gave me about 5 days notice of an Odette Thomas deposition from Mr. Bowen, and I just got that maybe a couple of weeks ago. I filed an objection to that and request for a motion for protective order, partly because of the timing in terms of the amount of notice that I received, which was less than 10 days, partly because it was a complete surprise to me that he would now be asking for a deposition after we both represented to the court just 2 months ago that we were ready for trial and participated with you, Your Honor, in finding and scheduling a trial date, and also discussing how the trial would proceed, that being an in-person trial with Ms. Thomas being allowed to participate by Zoom. And so if he's ready for trial, I'm not sure I understand why we would be getting a notice of deposition just a month before the trial. In addition, we're beyond the discovery period in this case, Your Honor. The first discovery was issued, and it was a request for production from Mr. Bowen, issued in April of 2019. The responses were due in May of 2019. The discovery period ended according to the rules 9 months thereafter, and the discovery period is passed. And so I don't believe that it's appropriate, given the representations made to this court by Mr. Bowen previously regarding readiness for trial and under the rules, the fact that we've been in this case so long and he's never sought the discovery or sought the deposition of Ms. Thomas, to now require us to go through this expense so shortly before trial and this urgency, particularly at this time, Your Honor, partly because my schedule between now and trial does not admit much time to have a deposition. And so I'm pretty well booked up between now and our trial date.
Judge, if Mr. Fuel is too busy to be handling this case, he should turn it over to one of his associates. The burden of that shouldn't fall on me and my client. And what is new with respect to this matter of surprise is that I did not have a copy of the partnership agreement. As a matter of fact, I don't have today a signed copy of the partnership agreement. It's blank unsigned, so I have no idea whether Odette Thomas would say this in fact that had been provided by Mr. Fuel is the partnership agreement, because it's, excuse me, is not signed, and the release of this partnership agreement under this court's order is provided me some issues that that my client is entitled to ferret out and determine their relevance before trial. I would cooperate with Mr. Fuel in any manner that's appropriate to schedule the deposition. I guess last case would be, and I'm not asking for a continuance of this case, but I guess in the final analysis, if Mr. Fuel just cannot, after all this time, try this case with me, then I would suggest to the court that a short postponement would be in order.
Your Honor, thank you, Mr. Bowen, for interrupting me, but Your Honor, that's really, we got a request for production for a partnership agreement after or on the cusp of the close of the discovery period. And so for Mr. Bowen to come in now and say, oh gosh, I'm surprised, I didn't know. Well, we've been in this case for more than a year. He's never asked for the partnership agreement until recently. And probably after the close, I could look it up if it makes a difference to you, but probably after the close of the discovery period anyway. In cooperation, we didn't raise those issues at that time, but for him now to come in and say, oh gosh, I was surprised, I didn't know, is again patently absurd. It's just not a credible argument. When he originally, I said, well, what do you want to do with Ms. Thomas? He said, well, I would accept a stipulation to the effect of a 2007 distribution and whether that distribution was made equally among the partners. Well, there's a couple of problems with that. One is for 2007, we're way beyond limitations on that issue. But beyond that, I prepared a stipulation. I discussed it with Ms. Thomas and she said, well, the distributions were made equally. And I so advised Mr. Bowen. And he said he would accept that stipulation. But when we got that stipulation out there, he advised me last night he was no longer willing to accept that stipulation. He still wanted to have her deposition. And I'm not, to come in at the last minute and say, I want a deposition and then complain that Mr. Fuel's trial schedule doesn't allow a deposition between now and trial is again, patently absurd. To want to go back to 2007 is patently absurd. I'm not seeing any validity to this request for a deposition at this point in time.
Well, basically, Judge, I'd like to respond to that and say that Mr. Fuel has been pretty free with his representations about I said this and I said that. His memory is not the same as mine, and I have attempted to cooperate with him throughout this entire process. And I guess the point that I would say is kind of appropriate to look at is to take note of the fact that this partnership agreement is not signed. I don't even know if that is the agreement that is supposed to govern the inner workings of this partnership.
Well,
But
that would
surely
suggest,
there's
that
no-
would
there's no
suggest,
reason-
Your Honor,
there's no
that
reason-
you
no reason-
interrupted me. May I interrupt you? May I interrupt you?
Answer is no. Answer is no. So Judge,
Well, if I may address it after Mr. Bowen is through speaking, Your Honor.
Absolutely, Mr. Fuel. Go ahead, Mr. Bowen. Mr. Bowen, you interrupted Mr. Fuel.
well,
I can't believe you didn't let him, I can't believe you didn't let him interrupt you. You interrupted him and he was a gentleman about it.
let me say if an apology is in order, I apologize. Let
Yes,
him
I think
go
an
ahead.
apology is in order because you
Let him-
interrupted him and he didn't say one word.
Let him go ahead.
Well, Your Honor, number one, saying that the partnership agreement is unsigned suggests that we would deliver to them a partnership agreement that's not the correct partnership agreement, which we wouldn't do. But number two, we would stipulate that that is the partnership agreement.
That's what I was going to ask you. Can you stipulate or who signed it and stipulate to that and stipulate it's the partnership agreement in effect and stipulate as to who signed it. But okay, I think that's a good solution. Okay. Are you done, Mr. Fuel?
Yes, Your Honor.
Okay, Mr. Bowen, please continue, Mr. Bowen.
Judge, a very key part of this dispute between these parties operates or rather deals with the issue of how the distributions were determined. How is there a vote? Is there a vote taken? And all matters that are key to the testimony that I have sought from Odette Thomas. As I mentioned just a few minutes ago, the availability of this court going ahead and continuing the case for a short period of time is open, and I would suggest would resolve any kind of disputes that we have. But I think that what I have presented to you hopefully persuade you that it is important for my client's presentation of her case is that this deposition of Odette Thomas be permitted. That's basically the nub of it, and I ask that you either allow that deposition to take place, or to go ahead and grant a short continuance so that the case may be properly tried.
And Your Honor, just one more comment. The how the distributions were made has nothing to do with the case. The complaint from Mr. Bowen is that his client didn't get what she was supposed to get from the distributions that were made to Mr. Ortiz. The distributions that were made to Mr. Ortiz are plain from the returns that Mr. Bowen has already received. Whether or not how those decisions were made about those distributions has little to do with the case, but the other stipulation we would gladly make is that the distributions have been made equally among the partners all along, which is apparent from the returns. But so I don't know why we would need that, but we're glad to stipulate to that.
Mr. Bowen, what's your response to that?
Judge, the tax returns that we have been provided show no distributions being made to Robert Ortiz, and that being that's a matter on the record. You shaking your heads. You don't believe that?
That's absolutely incorrect.
Well, it is absolutely correct. He he received no distribution, he being Robert Ortiz. And you're telling me that, and I'm telling you that that's what the tax returns show. And you're telling me that that's not the case.
Well, you're not, the
Let's not
problem
argue. Let's not argue. Just get the tax return. Get the tax return and let me see it. That's easy to prove. Why argue? I mean, I can't believe you guys can't even agree to something that's in black and white. So let's look at the tax return. Show me the tax return, Mr. Bowen, and show me.
It'll take me a couple of minutes to fish it
Fish it out.
out. Can we take a short break?
No, yeah, take a short break. I won't say anything. Do you know how to share screen, Mr. Bowen?
No, I don't. I'm sorry, I don't. Mr. Fuel, can you tell us when you say that Robert received a distribution?
well, so let's go back to 2007. You and I discussed that. We told you that the distribution to Robert was the same as the distribution that showed up on the tax return to Ms. Thomas. You said, well, I don't have a K-1 for Robert. I said, well, that was 2007. We couldn't find the 2007 K-1 for Robert. That was long, long ago. But we will stipulate with you that the 1,800 and whatever dollars that was distributed to Ms. Thomas was also distributed to Mr. Ortiz. But that holds forth every year that there was a distribution. In years that there was no distribution, then Mr. Ortiz didn't get a distribution, but nor did the other partners. So there were years where there were losses. There were years where there were distributions. So I just don't understand the argument. There isn't any mystery about whether Mr. Ortiz was receiving the same distributions that the other partners were. There's no indication in the tax returns, and nobody will testify that there was any other way that distributions were made. Mr. Ortiz's distribution for 2018, for the most recent distribution, has been held and not delivered to Mr. Ortiz because of this lawsuit. But that doesn't mean that the money went somewhere else or that somebody tried to engineer a distribution that would deprive your client of anything. It actually means that we're trying to protect all the parties and holding that money pending a resolution of all the issues in this court. I don't understand.
Well, I don't understand why you apparently believe that I and my client are required to accept what you have said on behalf of your client. That's
Well,
not. That's,
well, no, I'm not saying that. I'm saying that you
Yes,
waited
you
too
are.
long to ask for her deposition.
No.
The discovery period is closed. And you were asking for her deposition on a subject on which limitations has long passed.
well, that's for the court to determine, not for you to determine.
Well, that's what I'm saying.
Mr. Bowen, see, I'm trying to figure out the areas that you want to cover with Miss Odette Thomas, okay? So the first thing, if you say that you want to determine from her whether it was signed and who signed it, because you're looking at an unsigned document. Mr. Fuel is saying he'll enter into stipulations that it's a valid agreement, that it was signed by such and such, and it's a valid partnership agreement. Okay. Then the next thing you said is you wanted to see how the vote for the distribution came down. Is what I understood. Well, Mr. Fuel says it's really not relevant how it was done, and I kind of agree. So that's out the window. Your next allegation is, I guess, distributions made. The partnership's distributions throughout the years. Mr. Fuel has stated that you have received the partnership return every year since 2007. And in that return indicates the distribution. So I don't understand why you want to take somebody's deposition still, Miss Thomas's deposition still. Trying to figure out what you need to prove at this time, what you need to cover with her. And everything you've given to me so far has already been produced by way of production. And you don't have to take Mr. Fuel's word for it, because you said, why is it that me and my client have to take your word for it, Mr. Fuel? Well, you don't have to take his word for it. The partnership agreements are speaking for themselves. The partnership distribution, the partnership returns speak for themselves. They're not going to report something that didn't happen to the IRS. If they do, they're going to get into trouble, but you're basically stuck with what they report to the IRS. So you're not having to take Mr. Fuel's word for it. You've got income tax returns to prove distributions or not.
Judge, I've got the 2018 tax return right here in front of me. And for that year, there was a distribution of $101,000 that was distributed to three of those siblings. Mr. Ortiz's tax return shows not $101,000 distributed to him, but $202,468. That was a not a payment of a distribution, but rather a contribution to his capital account. So basically, Mr. Fuel has by mistake misrepresented to this court that the distributions were always the same. Well, that is not so at all. There was $101,000, dollar distribution made to three of them, and then he received a capital monies that he contributed to the capital of the partnership, $202,000. So that is a singularly striking fact that Mr. Fuel just told you in error. All the distributions have not been the same, and the part of that $202,468 that I'm looking at right now contained a de facto distribution of $101,000, and I'd like him to explain why he has said that his client received the same as all the rest of them. Well, he did not receive the same. He received $100,000 more, and moreover, there's a loan by shareholder Robert Ortiz for some $90,000 that essentially shows that there's some monkey business going on with respect to the tax returns and the distribution. So this is not an open book. Here's all the tax returns. The tax returns themselves, the one that I'm holding right here in my left hand, shows that there was monkey business going on.
Monkey business, Your Honor, is actually withholding from Mr. Ortiz the distribution to which he's entitled and setting it aside so that if this court finds that Mr. Bowen's client is entitled to a portion of that money is going to be there for Mr. Bowen's client. That's real monkey business there. I believe Mr. Bowen is misreading the tax return. It actually shows that there was not a distribution made to Mr. Ortiz for 2018. And again, the reason is that his share, the 101, is withheld. It's held by Ms. Thomas, and it's held pending the outcome of this suit, which is for the protection of everybody involved, and including the partnership, including Mr. Bowen's client, including Mr. Ortiz. You know, to tell me that that's monkey business, well, okay, then we'll let the money go and see if Mr. Ortiz can spend it before Mr. Bowen's client can collect it. I don't think that would be satisfactory for Mr. Bowen, but we could certainly distribute it and let that happen. That seems like a wrong result. Consequently, the decision was made to hold on to the money and not distribute it at this point in time for the protection, as I said, of all the parties in this lawsuit.
Judge, they distributed $101,000 to every single one of those siblings, except Robert Ortiz. And what they did in that instance was to say, well, let's not call it a distribution, because if we did, as Mr. Fuel told you, he says that they received all the same. Well, they didn't receive all the same. Most of all of them except Robert received $101,000, and Robert received, and I'm looking at it right here, it says current year increase $202,468. And
Oh.
He says that let's not call it a distribution, because if we call it a distribution, then it has to be paid to him. So let's call it something else. Let's call it capital contribution. Yeah, let's call it a capital contribution, and that way we don't have to give him anything, give her anything. And so basically, Judge, this whole business works down to a simple matter, that under the agreement that was entered into in December of 2005, his client was supposed to pay, the partnership was supposed to pay, and Robert Ortiz was supposed to pay, as was Odette supposed to pay a distribution. They didn't want to make the distribution, so they decided to call it something else. And the purpose has been to cheat my client out of the agreed upon $70,000 that she was to receive in exchange for a release of everything else that had gone on between these folks. So this is not a simple case. My client signed an agreement, obligated her to, or allowed her to receive $70,000, and they don't want to pay it, and want to act like that this is so simple that limitations has run. He cannot tell, Mr. Fuel cannot tell you, they cannot tell you when limitations began to accrue, because it didn't.
Your Honor, our position is that limitations is run. We don't have any further obligations to this lady. We have other positions also. One is that releases were signed that released the obligations to Mr. Bowen's client. The other position is that there was no consideration for the agreement. Those are issues that this court is going to have to decide. The $101,000 is a fairly simple matter. We would stipulate that Mr. Ortiz would receive $101,000 for 2018, but for the fact that he is in this lawsuit contesting the obligation to this lady. If he has no obligation to this lady, what happens to that distribution makes no difference. If he does have an obligation to this lady, that money is being held for the purpose of resolving that dispute. We would stipulate to that. Mr. Bowen wants to look at a tax return and claim that the partner capital account analysis suggests something different than I've represented to the court. Well, I've already made admissions about where the $101,000 is. So again, I still don't understand.
Counsel, I understand we're doing a bench on this one. This is what I'm beginning to hear. I'm beginning to get a little bit more of the flavor of this case and the dynamics. Counsel, and probably particularly you, Mr. Fuel, you have alleged defenses, affirmative defenses, statute of limitations, no consideration. Why aren't those handled pre-bench trial in a summary judgment?
Well, frankly, Your Honor, it's difficult to get a summary judgment. I didn't think we would get a summary judgment. And so I didn't spend the client's money on trying to get a summary judgment.
I mean, specific issues, specifically, those are good issues for summary judgment. The
Well,
statute of limitations is your own claim.
well,
No,
they may appear to be, Your Honor, but you know, my experience in everybody's court, in the state courts, is it's difficult to get a summary judgment. I had that issue with you in another case, and I'm not criticizing your judgment in any way, but I had two good points of summary judgment and you gave me one and denied the other. You know, you were probably right, I guess, but to say from here without seeing all the evidence that, gosh, you know, that's a summary judgment point. Well, maybe it is and maybe it isn't. And if we want to do summary judgments, that's fine. But if I spend a bunch of money on summary judgments, I don't know that I'm doing my client any favor if they get denied. So you know, it's just, there's a cost benefit analysis that goes with that. And if we want to now go back and do motions for summary judgment, I guess, and that's what you want to do, Honor, I guess we'll accommodate. We'll follow what the court wants us to do. We will.
I'm not going to tell you how to handle your case, but I'm just saying a statute of limitations is clear. Either the statute of limitations has run or not. And that's a good subject matter for a summary judgment, as well as no consideration. If there was no consideration, then that's basic. But okay, what are you going to do? Handle it in the bench as a directed verdict? Or argue at the bench?
In order to, well, I mean, the problem is in order to understand our consideration arguments, I have to go back a ways and I have to go back through some documents. And I don't know any other way to handle that. That's difficult to handle in a summary judgment motion because I'd have to track you through a bunch of documents and the law that relates thereto. But you know, so yeah, we're gonna be presenting those documents and presenting our arguments at trial and asking you to rule. So since it's a bench trial, I don't know that I would ask for a directed verdict. That wouldn't, I don't know how that would work in a bench trial, but I guess we could.
That's what I'm saying. Logistically, how are we going to do this? You've got defenses of no consideration, statute of limitations.
Right.
So how are you going to handle it logistically? Because what's going to happen is after we've tried the case, after Mr. Bowen has presented his case, not Mr. Bowen, after you presented your case, Mr.
Right.
Bowen is. after you have presented your case, you have basically tried it, you may have waived your defense of statute of limitations because you tried it.
Well, I'm entitled to a trial on any issue, Your Honor, so I wouldn't waive it in trial.
But if you're trying the substantive case, you may give up your procedural statute of limitations because you're trying it.
Well, I would have to disagree with you, Your Honor.
You can disagree.
Trial is the statute of limitations question, if it depends on any facts, regardless of whether they're contested or uncontested, is still a matter for trial if it's not determined in a summary judgment. The purpose of the summary judgment is simply to determine whether there are any disputed facts to go to trial. It's not to foreclose or bar or waive or result in a waiver of any of those claims made with regard to limitations.
But if you try the substantive part of the case, may not you waive the procedural portion of it? No?
Well, statute of limitations is partly procedural and partly substantive. So, and it is often factual. So the facts are presented to the trier of fact. In this case, that's you. And you will have to determine based on the facts whether our statute of limitations claim is a good claim or not.
Okay. Okay. Mr. Fuel, I'm not going to tell you how to try your case. I'm not. I'm just trying to figure out logistically how this is done. I don't know. I've raised all the issues that I might have, right? I think if you try the case, you may waive procedural matters or matters of law, and you may waive matters of law, maybe, if you try the case. Maybe I'm wrong.
Well, I'm certain, Your Honor, that that's not the case.
Okay, you're certain. I'm just raising the issues, wanting to make sure I take care of everybody. Okay, now we're back to, when is this case set for trial, Miss Becky? For Mr. Fuel or Mr. Bowen? When are we set for bench trial on this one?
At the 7th,
August 4th, Judge.
Oh my gosh.
2 weeks. It's
Yeah.
exactly 2 weeks.
Mr. Bowman, this is what I have to say. You've not given me any reason why you need Odette Thomas at the 11th hour. You've known about Odette Thomas since the beginning of this lawsuit, I think, right? Since you've been getting all these tax returns since 2007.
We didn't know that she was the managing partner, and anyway, that's
Well, Mr. Fuel stated that she had to sign the agreement. I think that, and so because she had to sign the agreement, you knew she had some kind of management position with a partnership, right? Because she had to sign the settlement agreement. Right?
I guess no, I don't agree with that, because if she was the designated managing partner in 2005, you know that it doesn't necessarily follow that she was the managing partner at this time, and so it's you know her testimony is so obviously crucial, and Mr. Fuel said something that I know he believes it when he said it, but Mr. Ortiz did not receive the same amount as everyone else, and we've made that abundantly clear from looking at what the tax return itself says. They thought they could change the outcome by just simply calling it something else. Let's not call it a distribution. Let's call it a capital contribution, and that old dog won't hunt.
Well, that's why we're having a trial.
Well, Your Honor, they made her sign for the partnership back in 2005. And why would they make her do that if she were not the managing partner?
Right, but what he's saying, he didn't know in 2018 or 19 or 17 or presently that she was the managing partner, because she could have been changed.
Well,
Exactly.
the
Managing
partnership,
partner in 2005 doesn't mean she's a managing partner right now.
well, but
Exactly.
the partnership agreement was executed before this 2005 settlement. If she was the partnership, if she was the managing partnership and he only learned that from receiving the partnership agreement, that would suggest that this idea that there's been a change of office somehow that surprised him is, again, doesn't logically follow.
Judge, one thing that I perhaps have failed to properly illustrate and point to is a fact that these tax returns, which I have in my possession and Mr. Fuel has them also, shows that Robert never from 2005 through 2017 ever received a distribution. And he's wanting to talk about, well, they all receive the same distribution. All you have to do is look at the tax returns, and you see that that's not so.
Well, that's
Robert received no distribution, never.
that is an incorrect statement. It's not borne out by the tax returns.
Then tell us what tax return shows that.
Well, let's go back to the 2007 tax return that shows that all the partners got a $1,800 and something distribution. Let's pick any of the tax returns.
In 2005?
We want to go through them all right now, Your Honor.
Well,
mean-
yeah, you guys have to learn how to screen share. Because, yeah, you guys can say whatever you need to say, but you guys don't show me.
Well, I would be, I wasn't prepared to try all the tax returns right now, but if you want to,
I'm just saying, you guys, for a bench trial, we need to start learning how to screen share, please.
we will be prepared to do that but Your Honor, are we going to be trying this on Zoom or are we going to be trying this some other way?
Zoom. We're not allowed in-person hearings yet. Are you okay with that, Mr. Fuel and Mr. Bowen?
Well, we're okay with whatever needs to be done. I mean, in other words, if you need to do it on Zoom, I guess we'll figure out how to do that.
Yeah, it has to be. I'm not allowed in-person hearings yet. You want to postpone it until we do in-person hearings? We can do that too. I mean, I'm
I don't want to do that.
trying to accommodate everyone.
Yeah, I mean, I'm glad to do whatever the court wants to do, but I don't see the point of delaying things. But, you know, as far as screen sharing, I'm going to be doing some screen sharing tomorrow with Judge Gamboa, so somebody's going to help me with that. And I'm sure I have to get somebody to help me with you also, because I won't be able to do it myself.
Okay. Okay.
Judge, as I believe I pointed out to you a couple of minutes ago, if you order that deposition to take place, we'll cooperate to the maximum with Mr. Fuel to accommodate his schedule. If we don't handle it in that fashion, then perhaps what needs to take place is to go ahead and put the case off for as short of time as you can allow for us to deal with it. So I think it would be unfair, not on your part, but just unfair as the circumstances work their way out, for us to have to try this case with the paucity of information that we have at this point.
We have all the information that's needed to try this case.
Well, you're mistaken with respect to this issue of the distribution being made to Robert, because the tax returns that you provided to me show that he never received a distribution.
Well, then you're not reading the tax returns correctly.
Well, then tell me what year I need to look at.
Well, why don't you tell me which year you think there's no distribution besides 2018, which I've already explained to you. Which we did.
You say that he received a distribution every year, or that
I did not say he received a distribution every year. I said in years there were losses, in some years there were not.
What you said was that they received the same distributions every year.
Yeah.
They received the same distributions every year, and they didn't.
No, Mr. Bowen, what he said was this. In some years, there were no distributions because there were losses. Some years, there were distributions, and when the distributions were made, when the company made money, they were equal. That's what he said.
And he said that, and he's mistaken in that regard.
Well, show me where I'm mistaken.
Are we going to try this case on Zoom or not? Is my first question.
That's a good question, Your Honor. I'm prepared.
Because look what Mr. Bowen just said. We've been trying to work towards a resolution, trying to get this tried, and now Mr. Bowen is saying, I really don't think I'm ready. Which I'm very frustrated, very angry and very frustrated.
Well, if any of that is my responsibility, I apologize to the court, but
because what he's basically saying, he's hog tying. What you're doing, Mr. Bowen, is you're hog tying this court. You're saying if you don't grant this deposition, if you don't grant the fact that I need, then I'm not ready for trial. That's what you're saying. And that makes me very angry because you're hog tying me. You're bribing me. You're a bit extorting me. You better decide this way, Judge, because if not, I'm not ready for trial. And that just isn't how the practice of law is done in my court.
Well, I apologize to you if
No, that's what you said. You don't need to apologize, but that's what you said and that's what you just did. And I'm very angry and very upset because you don't do that to a judge. I'm trying to move these cases. I really am trying to move my docket. Absolutely. For your benefit as much as for mine, for your client's benefit as much as mine. And on the 11th hour, 2 minutes, 20 minutes before trial, I'm not ready if you don't grant this deposition. I'm not prepared to go. When we've had 2, 3, 4 pretrial conferences, and every conference, you're ready to go, Mr. Bowen. You don't do that. You just don't, Mr. Bowen. Okay. Are we ready? Are we going to go to trial or not? Simple. I'm not going to sit here watching you two argue anymore. I'm pretty fed up and frustrated. Is this case going to go to trial or not on a bench on Zoom?
I would prefer that
yes, Your Honor.
I would prefer that it not without that deposition, but I'm not going to criticize your effort to do what you think is right. But they're just.
You see, he did it again. He said it again. Say it again, Mr. Bowen. I'm not going to be ready if you don't grant me this deposition. This is 11th hour. You're out of time. I've told my civil attorneys time and time again.
Let me ask.
Don't interrupt me. Don't interrupt me. I'm not going to let you interrupt me, Mr. Bowen.
I'm sorry,
And I'm
Judge.
not going to be nice about it either because I'm pretty much fed up. I think what we need to do, somebody pay a jury fee and it's going to the jury. And we'll try this in 3 or 4 or 5 years. By the time your client gets any money, if so, it'll be 3, 4, 5 years from now. That's what we need to do, I think. That's what I think I want to do.
Judge, could I ask a question of Mr. Fuel? If we went ahead and tried this case on the 4th, do you have any objection to the experts that we have given you, and do you have any problem with that? Because if you don't, then maybe I can go ahead and agree with you to go along with trying it on the 4th. Do you have any objection to the experts that we've designated?
Well, so you just designated experts and you've designated them outside the period in which experts are permitted to be designated. It's untimely. And yes, we do have an objection.
Okay, so you wouldn't agree to that in order to get this case tried on the 4th?
Well, you realize you just designated the experts. We're two.
I realize what I have done. Yeah.
Okay, so yes, I do have an objection.
And
your experts should not be permitted because you waited too long to designate them. We sent requests for disclosure in May of 2019. And I didn't get any experts disclosed to me until just a few days ago. It may have been Friday.
Yeah, there you have it. He's
Right.
not willing to make any kind of accommodation to allow this case to go ahead and proceed. So
So it's my fault because you
No,
designated your experts too late.
Okay, gentlemen. Okay, gentlemen, this case is not near anywhere settling, and I thought we had done a good job of having status conferences, getting together. Mr. Bowen, the problem is, and this is the problem, Mr. Bowen, you decided to do everything at the 11th hour. 2 weeks, 3 weeks before trial to designate experts. That doesn't give Mr. Fuel an opportunity if he wants to find controverting experts. That doesn't give him time to do any of that. Really, it doesn't. We're going to put this on the trial track is probably what we're going to have to do at this point. I don't see anything else is to put this on the trial track. Mr. Bowen, it's very disappointing to me that you waited to the 11th hour for everything to try to disclose and get everything done when we had hearing after hearing after hearing the last 3 or 4 or 5 months.
I would still request that we go to trial on the 4th, Your Honor.
Well, I mean, you've got experts that you're going to object to, right?
Right.
Okay. Okay, it's Mr. Bowen, you need to, and I've said this to all my civil attorneys, you need to follow the scheduling orders, the deadlines, because that's the only way I'm gonna move a case.
Judge, I don't recall getting a scheduling order from you, and I'm not saying I didn't, but I don't recall getting a scheduling order.
Oh, you
It
probably didn't.
It doesn't matter. We're all here trying to do the best we can. And so,
You probably didn't because everybody said it was gonna be a bench trial. You're right, but there's rules of civil procedure that you gotta follow. So it's not like, hello, footloose, fancy free, we don't have to do anything. So there's rules of civil procedure that had to be followed that I thought would be followed. I think what we're gonna do is just put this on the trial track. Did Mr. Bowen?
I know you're going to do what you think is right, and I don't have, and I'm not going to quarrel with you about what's right under that circumstance. I've made the pitch. I've made the
This
pitch.
is what This is what makes me so angry. You just said you won't agree to anything. If I don't give this deposition, you're not going to agree to anything. Now we have the other issue of the experts. You may go be in trial without any experts. This just stinks all the way around. Just stinks all the way around. So I think this is not in any posture to be tried. It is not. Mr. Bowen, these 11th hour requests, discovery, disclosures just are not appropriate. Are not appropriate, number one. Hog tying a judge and kind of bribing a judge, extorting, saying, okay, if you don't do this, then I may not agree to proceed and go to a Zoom hearing. And I'm stuck. You guys have to agree to Zoom or not. If you guys don't agree to Zoom, I can't force you to do Zoom. So that's the frustrating position I'm in. Because I don't necessarily want to give you your deposition. However, this thing is not going to be tried in August because you're going to object, Mr. Bowen. And that's the situation this case is in. We all find ourselves, and I'm not happy. Okay? So I think we're just going to put it on the trial track. Your clients are going to wait 2 years, 3 years, 5 years, maybe. If they get any money by that time, it's going to be worth 20 grand, not 70, because what's the present value of 70 grand? Sorry. It's not ready for trial. Okay. So I guess I'm saying, I think we're going to have to put this on a trial track. You guys want a bench? Go ahead, do a bench. We're going to start with brand new scheduling orders, limits, deadlines. Mr. Bowen, you better follow them. You better follow them, sir.
Yes, ma'am.
What else? We're getting this off the bench trial track. We're not going to trial in August. What else?
I have nothing further, Your Honor.
Okay. Anything else, Mr. Bowen?
That's you know, you might give it 10 days, and let's see if in that 10-day period that Mr. Fuel and I have come to terms on any of this.
You can give as much as you want. You can come anytime to me and tell me case settled. You've got all the time you want.
I don't think we're going to settle it, but I think we could come to some agreement with respect to the issues that you've wrestled with this morning.
Okay, go ahead. If you propose to me something that you all have agreed to that I'm comfortable moving forward, because I'm not comfortable moving forward in any shape or form in this case. You come up with stipulations and agreements, etc., that I'm comfortable moving with it, I will. If not, oh well. Oh well. I've got lots of other cases that I can deal with. Trust me. Where lawyers aren't hog tying me. If I don't do this, then I'm going to do this. So I've got lots of cases where I don't have lawyers doing that to me. Mr. Bowen, are you a local attorney?
Yes, ma'am.
Okay. Okay, sir. Very good. Okay, everybody. Anything else? Goodbye. Have a good life.
Thank you, Your Honor. Appreciate it. Thank you for your time.